what we are seeing appears to be a draft, and that they want to consult on that draft. From what I have seen as a former information minister, this draft is dangerous, though it's not surprising. And let me explain why it's not surprising. It's not surprising because I think the president first announced it, that they are going to use the national security apparatus to go after people who make comments on social media that they consider, for whatever reason, whether it's under hate speech or it's under whatever, they consider it unfavorable. They're going to search for your IP addresses and then get the security apparatus to go after you. The president himself said it. So it's not surprising that his minister is now following up with a draft bill with such wild provisions in there. What is dangerous about it is that over the last set of decades, various countries have been moving away from criminalizing speech. There are other remedies for speech that may be deemed unfavorable, most of them civil, but not necessarily criminalizing it. Even the Criminal Libel and Sedition Act was repealed by the Kufuor administration. There are still remnants of laws that still seek to criminalize speech. For example, this law that is being used a lot, publication of false news, with intent of causing fear and panic, is one of those laws that actually still needs to be repealed. Instead of repealing that to advance, democratic freedoms, the government is now seeking through this draft that it wants to consult on to enact legislation that will now even ensure that when you put up a comment in your chat groups and they find it offensive according to their criteria, you could go to jail. And I think it's a very dangerous, encroachment into the area of free speech. The government needs to tread cautiously.
Right. And I know that just too many of you are waiting for the explosive SML investigative report by the OSP and the subsequent swift action by the president. Almost in a similar fashion, when KPMG did its report, President Akufo-Addo didn't delay in swiftly terminating some of the contracts. And then just when the OSP also finished, President Mahama didn't delay in instructing that all other outstanding contracts should be terminated as far as the SML is concerned. The OSP has used some very, some language, very harsh about the deal. He says it looked like a masterful and mischievously crafted scheme designed by Mr. Ofori-Atta as the chief promoter, patron, and sponsor. He says it was a deliberate attempt to manipulate the procurement process, introduce a redundant private actor, that the company was incorporated for the sole purpose of employing it as a vehicle to ride on official patronage, and all sorts of claims have been made. And so Ken Ofori-Atta and 5 others are in trouble. The OSP, as we understand, by this process, they have saved the country 1.25 billion. And they are in the process of the prosecution hoping to get, 125 million Ghana cedis as well. So just hang in there. We will get to that issue shortly. But if you have been hanging on social media and doing so anonymously, let me inform you that the bill that is to be passed, if it is passed in its current form, you will be in trouble. If you assume a false identity to anonymously harass or stalk any person, you are likely, if you are found, it's an offense. And if you are found guilty, you are liable on summary conviction to a term of imprisonment not less than 1 year and not more than 10 years, or a fine not less than 100 penalty units. So you multiply 12 times 100. It will give you the Ghana cedis you need to pay, the minimum, and not more than 10,000 penalty units. 12 times 10,000. How much does that give you? in some instances, you could go to jail for 5 years and may be paying a fine of as much as 300,000 Ghana cedis or 60,000. So, we remember the Spybill, postal packet, 2016. And it was my good self, as the minister then confessed, that our proposals and our criticisms that led them to withdraw it. Let's see this time if Newsfile can once again inform some tweaking or removal completely of this bill. Why should it be removed? Gentlemen, let me come to you. I think I should start with Sulemana here, because you are in that space, and in recent times you have been campaigning against the similar-like provisions in the Criminal Offences Act and the Communications Act, Electronic Communications Act.
Yeah,
what's wrong with the bill?
So it's a draft bill, if I may call it.
Yeah, it is seeking to introduce 22 new sections by amendment, and then it also wants to have 28 new sections inserted into the bill. So in all, 50 new provisions.
First of all, I think that as a country, it is right for us to be concerned about the evolution of technology and, of course, the benefits that come with it, but also the challenges that we can have. We certainly should be concerned about the crimes that can often be perpetrated online. We certainly have to be concerned about situations where people use digital platforms to incite violence. We've had communal violence in this country that, to a large extent, if you ask people involved, they will tell you that they strongly believe that the influence of social media, in inflaming the conflict has been so significant. And so certainly as a country, and people lose money all the time through cyber fraud and all of that. People go behind the scenes, create anonymous, identities online and use it to stalk people, use it to either attack people, to threaten people. I remember an incident where somebody wrote to, Manasseh threatening him, and the case was reported to, the Cybersecurity Bureau of the Ghana Police Service. Until date, nothing has happened and all of that. So I'm raising all these to say that it is important that as a country, we take steps to see how we address some of these challenges. And of course, the whole question about mis and disinformation is a phenomenon that is getting global attention, and nobody has been able to identify the most appropriate responses to it. The digital companies started with this whole thing about fact-checking. Increasingly, we are being told that it is not the most effective way to respond to, the phenomenon of mis and disinformation. As we speak in the Sahel region, where we have these coup d'etats, there's a lot of concern about how mis and disinformation is being used to prop up certain leaders or to push certain narratives and all of that. But having said that, I think, Samson, the draft that I have seen is a terrible one. And I don't know why any people would think that as a democratic state, we should have a piece of legislation like this that basically grants discretionary powers to the minister, to the authority, to basically do anything, to snoop on it, to basically intrude if they want, if they choose to.
And we'll be happy as you speak if you can refer to specific portions rather than general.
Yes. Yes. Let me just refer you to, and there are several. So, for example, if you look at, you lawyers call it Section 35, right? So where it talks about the minister may, on the advice of the authority, designate a computer system or computer network as a critical information infrastructure. If the minister considers that the computer system or computer networks is essential for national security, it's understandable, the economic and social well-being of citizens, a bit controversial. What does that mean? If you say a network is essential for the economic and social well-being of the citizens. I think what we are doing here, what multimedia does, is certainly of the economic and social well-being of the citizens. But if you come to subsection...
Which provision have you just looked at? Proposed provision is that?
So what is number 35, 35.1?
Right.
So if you come to the subsection 3 of that, the minister shall, in making making a determination under subsection 1, where the minister is empowered to designate a computer network as a critical information infrastructure, consider the following. And part of the consideration is if whatever is being done affects an international business or communication or affects a citizen of Ghana or any other international business in which a citizen of Ghana or the government of Ghana has interest. I mean, how do we ensure that this is done? Then there is another one that says any other services determined by the minister on the advice of the authority. This is quite vague. The authority, if they choose to say, okay, what multimedia is doing, we don't like it, we come here and say, okay, we have designated your computer systems as a critical national infrastructure because what you do affects, the well-being of our citizens. It has implications on international business, local businesses, the economic activities of people, and all of that. But I think what is even more worrying, which I've actually highlighted in red, is down there where we have section 59D inserted. So this is number 26. It says the principal enactment is amended by the insertion after 59C of 1, application for production order to collect computer data. And it says 59D, an investigative officer, and remember that the amendment now empowers folks at the Cybersecurity Authority to have the powers of the police, and to prosecute and to arrest, all of that.
The current law, they already have inspectors.
Yes.
Except they do not have the powers of the police.
Yes,
okay.
But now this is granting them those powers. And then it says what? An investigative officer may apply ex parte. And I believe that is what you normally would say, they go on your blind side. So even without your notice, ex parte to the High Court for a production order to collect computer data. Then it lists some of so a production order under this section shall require
There's something I wanted you to pay attention to.
Yes.
The first provision you read, which you have highlighted, which you don't like. The current provision, section 35, designation of critical information infrastructure. It reads, the minister may, on the advice of the authority, designate a computer system or computer network as a critical information infrastructure. You see the same wording?
Yep.
If the minister considers that the computer system or computer network is essential for A, national security, or B, the economic or social well-being of citizens.
Yeah, but there are several others now added. And I'm saying these are fundamentally vague and it grants discretionary powers. If a minister, and the minister on the advice of the authority, I think that is just some wording. If the minister decides to act, basically on the advice of the authority. And then you have what I was reading, where an investigative officer makes an application under section 1. That investigative officer shall, it talks about explain why he believes that he needs that ex parte, authorization granted for you to produce data. So what it means is that you can be here and then you receive a notice that your communication data is being requested. And the law criminalizes that if you decide not to grant it.
If you obstruct.
If you obstruct, not to grant it. And something I'm saying, you read it in entirety, and I don't know what informs the decision to go this way.
Do you know that presently, if your telephony records, if there's a suspicion that you're using your phone to do some act which is wrong, the police are allowed to go to court ex parte, as you find it here. That means on your blind side, without your knowledge.
The police?
Yes.
The police.
And they go, and the court grants them an order to go to the telco MTN or whoever they are, and then they'll get your telephony record.
No, so that's why I kept repeating the police, the national, the establishment that is supposed to fight crime, deal with crime, law enforcement, we all understand. But if now we now grant another institution the powers of the police to be able to, go as party, seek, behind, get a court order without your knowledge.
Is it the suggestion?
And
is it the suggestion?
It says that.
Is it the suggestion that the police are prone to be more professional than officers of the cybersecurity office or the inspectors who are presently in the cybersecurity office?
No,
that one group can do mischief, but one group will not do mischief. Is that it?
No. If we begin to have a situation where in this country we have duplications of institutions doing the same thing with discretionary powers, I don't think that it is good for our democracy. I don't think that it's even good for national security itself. And that is why I think if we have a situation where the police can already do that, and the existing law can enable officers of the cybersecurity authority engage and partner with the police to say, look, this is what we are discovering. And that is why the police, I believe, has a cybersecurity unit. I mean, it is not for nothing that the police, as we have it, has a cybersecurity unit that deals with cybersecurity issues. And when these matters come and they have to go to the court to get ex parte authorizations and whatever, I think the cybersecurity unit will do that.
There are law enforcement bodies that have been giving police powers. You don't have any problem with that. You have the EPA that can do things. They have inspectors, all of these. What's the problem?
No, so you see, like I said, the police already has a cybersecurity unit. I'm not saying that, therefore, we shouldn't have the cybersecurity authority. If the cybersecurity authority is supposed to be an expert institution to be able to support investigations, identify issues, and work with the police cyber crime unit to deal with matters that come up, I don't have a problem. But to now have this piece of legislation drafted with, as I said, I mean, if we had a time to go through, because I've highlighted so many places, application for preservation of data.
No, that's small bits. And once again, remember that the guests will take a position and that will be adverse to the law. And my job is to read it and reflect back to them. It doesn't mean my views. You don't want to hear what my views are on this law. We just passed the Gold Board Act. And we have given the inspectors there police powers, go around and arrest people and do things.
Wow.
What's the difference?
No, but the fact that others are doing it doesn't make it right.
Okay.
That's my position. To now begin to have almost every institution having the powers of the police. I think that we will be creating chaos, anarchy, because you never know how an individual may want to act against you, especially if the person has those discretionary powers. And that, for me, is the problem. And I want to believe that this particular draft, as I said, and the problems that are in it would be something that I believe those who are promoting it would sit down and then reflect on it and say, look, today it is you. But remember, tomorrow it can be used against you. Sometimes that is what happens. When people are in power, they feel, okay, well, we are in power, at my discretion I can do this or I can do that, but the next time it will be used against you.
Okay.
I don't think that as a democratic country, this is the kind of legislation that we must have in terms of dealing with the cyber security issues that we have. As I said from the beginning,
thinking you will go first
issues.
to the, media, practice linkages.
And there are so many, like I said. So if we are investigating something about a powerful minister or something, I mean, basically somebody goes to the court ex parte to say, look, these people, we suspect that they are doing something that is wrong. And basically you are ordered to produce your records. What it means is that even the issues of confidentiality of sources and all of that, you may not even have it anymore. Because once a court orders that your laptop must be produced, you produce it. And then everything in there can be viewed. I don't think that we should get that.
That can only happen if you are suspected as involved in a crime.
Exactly. But in this case, cyber crime could mean a lot. you are using your computer to snoop on somebody, or there is a suspicion that, you are stalking on somebody. There's a suspicion that you are using your computer systems to deal with child online protection issues. A lot of issues can be raised. And like I said, it is important we deal with the cybersecurity concerns that we have. But whatever piece of legislation we are introducing must be, as they say, justifiable, proportionate, and necessary.
Okay. Richard, which parts are problematic for you? Kujopon Nkrumah says we can trust that they will oppose these obnoxious parts of it.
I'm saying, the whole show.
The whole show?
The whole show. Like...
Oh, the portions that wants to improve the conditions of service of the people there, all of it should go.
I'm saying that, when you're in class and then they teach and the teacher sometimes you don't understand.
That's an example.
And which part don't you understand? The whole show. The whole effort. The motive behind it is not good for our democracy. This is not cyber security they are fighting. This is cyber coup that they are orchestrating on our constitutional rights. They are determined to curtail our rights. And I think that we shouldn't just countenance it. I mean, there is another bill that I think is working its way along this. There's disinformation, hate speech, and publication of other sorts or something. What is all this? What is the problem? Like, really, what is happening? Like,
in fact, that one, there is some protection for you, the politicians.
And I'm just...
So that people don't vilify you anyhow, the way they do
but you know who the protection is for?
It's for you, the politicians.
The supreme leader. He is trying to gather this protection for himself. Nobody needs that. This thing they should quietly disappear with this thing. We are quickly becoming a police state. Look, this whole thing is going to promote surveillance on citizens, okay? It's going to give them needless powers to invade, intrude into our privacy, and they can do it at will, and you have now added police powers to that, enhance their ability to freely just move into any space. I'm talking about they can come here and take over your computers by, I think, a notice of 7 days that they are coming here. They come and look at your computers, and if they feel that you're doing something they are not happy about, Khalid, this is what your government is doing. Before you came, nothing broke with anything. People were talking just fine. You leveraged that to come to power. Now suddenly, you don't like
what are we doing?
Freedom of speech.
What are we doing?
I'm saying that.
You have the greatest freedom of speech in this country.
Wait. You see, I'm saying, this thing is terrible. I think, is it 67A, I think Section 6 there, talks about, impersonating, if you can just find me, using a certain identity to send certain information into certain platforms and whatnot. And I'm just saying that who would determine how offensive the matter is that you are posting in a certain social media group or that you are communicating? And so government is not happy with that we can't talk anymore? I find it very offensive. Look, we have enough rights on the books, okay, to protect anybody. Now you have a situation where, if I say something that defames you, that you feel is inappropriate, that besmirch your character, you have a civil remedy that you can pursue. But now we are talking about a criminal act. If you and I get into a conversation, or I send you something and you find that you don't like it, how is that going to help us construct our roads? Is that what really is our priority? How is that going to help us provide jobs? I don't know, you forgot about that. That was why you won election. You said you had some 24-hour economy stuff that you're coming to do. Where is that? Khalid, where is the 24-hour economy? There's no jobs being created. Up and down this country, people are out of jobs. Young people are wailing. They want jobs. You haven't created that. You are busy writing legislation left, right, center. To what end? If nothing at all, Samson, we should be able to talk. There is no democracy without free speech. This curtailment of our rights, this effort to snoop on citizens, this bill that is coming to completely do away with our rights, our constitutional rights, I don't think that is right. Specifically, we know what Suleiman was talking about in relation to the police powers that is given to them. I think it's excessive. Look, if you have the police doing this, yes, I had concern with the gold board situation with the policing, how they would be able to exercise it. Because the police service has evolved over time. They have mastered the act of policing. And even then, they are still improving. They are still building. There are instances where you think that you see them committing excesses. And so to hand that power to a certain authority that is created and seeing the sensitivity of speech, I'm focused about that.
Let me ask you one.
In a political space, in a democracy.
Let me ask you one small harmless question. So when the postal packets bill was introduced in 2016, the NDC was in government.
Yeah.
You and I, we came together and fought them.
Right.
I remember how, because it was an election year, the suggestion was that they want to intrude, they want to intercept Akufo-Addo's communication and all of these things. They withdrew the bill, right? And they came forward here on this platform to say they've heard us, they've withdrawn it. Guess who passed that bill later in 2020? It was your government.
Yeah.
And the things we cried against were not removed. They were still there. So I wrote and said, among other things, that this is a publication, an interview I gave. And I said that portions of the newly enacted law are the same as the contents of the Postal Packets and Telecommunications Messages Bill, also known as the Spybill. That was sternly rejected by a section of Ghanaians when it was laid before Parliament in 2016. In fact, Akufo-Addo joined the campaign. So I said, quote, this must be a lucky government. That's your government. All the organizations and individuals who joined in that war that forced a review and eventually got it shelved have been in deep sleep. They have been in a coma. Remember President Akufo-Addo, the NPP joined me, the telcos, Ghana Bar Association and others to kick against the spy bill. So the very things we protested, including that dangerous backdoor approach to invading privacy without recourse to a supervision, without recourse to or supervision of the court, is now law in this Cybersecurity Act 2020. And that's really only a new name. This time, hefty sanctions, including fines of up to 240,000 or more, plus 5 years in jail, await people who breach this law, including the telcos and their CEOs. In fact, in this law, the present law as it is, you could go to jail for up to 25 years for some offenses.
Yeah. So something, I don't think that there is anything wrong with seeking to protect the cyberspace. There are genuine concerns there that we need to try and work around. But using cybersecurity to protect our digital space as a political tool to oppress, to silence dissent, and weaponize that to prevent citizens from freely engaging in democratic process, I find that to be reprehensible. I find that to be unacceptable.
My point to you is that if that is the aim, then we already did that in 2020.
Well, the point is that
why law we are asking to amend.
Well, I don't see the blatant insertions that I'm seeing here. You understand? And even that, if it's a process, we can look at it and amend it. But I'm saying that anything you are doing that curtail people's ability to participate in the democratic process, you are drifting away from democracy. Fundamental point. And this bill and its cousin, the misinformation, disinformation, is leading us on that path.
Interesting.
So my goal is that let's throw this thing away. Okay, let's take a clean sheet of paper and start again. This thing here cannot suffice. It shouldn't be anybody's idea to bring this to Parliament and to try and do anything. Because now they have what they call the supermajority in Parliament, so they feel they can do anything. In fact, that in itself is a temptation. Okay, that you guys need to resist, that you feel you can do anything. And then there's a motion to stop you from vetting the Chief Justice nominee. You say you are not going to listen, all the noises we are hearing, but this thing is wrong. Okay, you are undermining our democracy, and I don't think it's right. You know, but in this bill, if you come around again, the component in there, which is talking about certification for professional bodies and people in the digital space, I think is very draconian. It's going to put burden on businesses and professional organizations, censorship, and to a large extent, increase the cost of doing business because they have to pay money to be able to obtain this certification.
Now, Prof, am I allowed to give small advice?
Absolutely. Yeah.
That you do a comparative analysis of the existing provisions in the 2020 law and check them with the proposed amendments. And then you may come to a better place to help your group in Parliament to fight what has to be fought. Once again, you don't want to know my view on this bill.
Okay, well, yes. I mean, Samson, thank you very much.
I'll respond to your small advice.
You see, there's something I've learned in my short life in government and in opposition, right, haven't had both experiences that you don't personalize legislation. Because when you personalize legislation, you're going to leave someday, another would come. And when you personalize it, you are blinded not to see. So with such legislations, I always call for a bipartisan perspective to it. And, you know, we've been here for probably half an hour taking our turns in the criticisms of the set proposed, I don't know, in these draft stages. And it's been very sweeping rather than very specific to pick point by point to say what it is. I'm not criticizing, I'm welcoming the views. In all of this, I don't know the extent to which the consultations have gone, but I think that the cybersecurity network in the country in terms of professionals, civil society organizations, etc., those who matter and have their work directly related to this ought to be consulted to see the way forward. Sometimes, Samson, legislation is a very difficult process. And the most difficult processes or stages of legislation is drafting. That's the use of language. Sometimes the intent is not as it reflects on paper, which is why you need to get very astute drafters to help in the process. Now, having said that, it takes me back to a sister or a mother kind of legislation within the European Union or possibly the UK, which was called or nicknamed the Snooper Charter. And that is, by that I refer to the IPA 2016, which is the UK's Investigatory Powers Act. This has been described by its critics as the most, controversial surveillance law in the democratic world. Now, when it comes to issues of national security and surveillance and in how we expand them, they are a very difficult process. We talk about child molestation or online and protection. We're talking about protecting the rights of individuals being maligned. I know, Sule, sometimes I see your photos up and people writing all sort of stories about you taking bribe on the blind side of Manasseh, which we all know is not true, but we know that's just on a lighter note, yes. But to protect things like this. But the description and where the partisan perspective from where Richard is coming from is what I think we all should move away from, comparing it. For a government that said, or an opposition party that said we don't eat roads, today, because of a legislation that is being put in place when we've just launched a big push, you are asking whether we have created enough infrastructure to talk about legislation. But that does not mean that the cyberspace is a jungle. It needs some form of regulation. But all I'm calling for the drafters and the promoters of this act is that, look, let's judge all with the civil society organizations, let's judge all with the relevant agencies that matter. But Richard made a very dangerous point. How do you allow people or practitioners within the cybersecurity space without certification, without the right vetting process, etc., etc. I know some of the wording are very front-loading in how they appear in form, right? Some are very vague in how they appear in form. And I think this is just draft stages, which is why we have a constitutional process in Parliament as to how, or a parliamentary procedure, how a bill goes through the various stages, right, before it finally gets a presidential accent. So for you to come out on a first draft, I don't know if it's a first or second draft, but early stage draft, to be this critical, I think would not help the discourse. I don't know also.
You don't criticize this.
No, I said.
It will end up the same as the law.
Yeah.
You know what happens in this town.
Yeah.
And you know how long they've given to all of us to contribute?
How long?
14th of November.
Yeah. So I'm going to come to all of that. That's why I say they have to, because I took, to help with the discourse, I took some key elements of it, like interception of data and acquisition. I find that very interesting. I think that's something we really need to look at. And the sort of powers, instead of giving the powers to the court, we give it to individuals within these agencies. That's why we say we shouldn't personalize. Because when you give such powers to individuals within the agencies, because the court takes a process, it is slow, and it hears both sides of the opposing and whatever views it is. Now you have the also taking freezing orders.
No, it's actually ex parte applications.
Yes.
So the court doesn't hear.
Yes. So I'm still.
There's always a criminal element.
Yeah.
So you don't want to hear the other side.
Yes.
Before you go and stop the activity.
Yeah.
Then give the other side the opportunity to also come in later.
Yes.
I don't remember when the police went and said, give me ex parte, and the court ever refused.
I know within the European Union, you still have the police that are investigating to have those powers, and the court, right? So we may want to, look around best practices and also localize to have a fit for purpose case. And I think that's where we are trying to get to. Also, the 14-day freezing orders before you go to the court to apply, to have all of that. Because look, sometimes certain businesses, if you target a businessman who has a conversion cycle of probably 91 days or whatever it is, you go for 14 days, you halt his business, right? And at the end of the day, you realize that it was just a red herring. What happens? So there are critical issues to take. Then also you think about state protection and the interests of the state. National security, it's paramount when it comes to this.
National security is an unruly horse.
Yes, as you would know. So the diction around national security issues, I go with them with the greatest humility, and also knowing that I'm not an expert in the field, and also knowing that the state interest is supreme. So I think that these are issues that we should not be very partisan about. But Sulemana and your good self, from your experience from civil society and the legal practitioner perspective, you all have contributions to make. And I said, these are early draft stages. Let's all come in and see how we can shape it, right, to have the supremacy of the state interest and to protect ordinary citizens regardless of party coloration.
Let me go to your colleague, Professor. So, Dr. Saikwa, I thought we were all worried about how cyber crimes are increasing and how they are going fast ahead of legislation. And so there's need for something to happen. Your very good friend, Professor Bafo Ajimandua, formerly with the CDD, former UN governance advisor, he has had his phone hacked, and people are using, his number and name to make all manner of bizarre financial requests. He's been very distressed in this week. This is some of the things we are seeking to check. What's our problem?
Well, I think the problem or part of the challenge is, as Prof said, how do you balance the state's interest in protecting certain domains against also ensuring that you do not violate certain fundamental rights of citizens as protected by the Constitution. And that balance is not always an easy balance to achieve, because as you mentioned in Prof. Bafo's case, I was one of the people who got that message from the person who hacked his phone. And, if you are able to trace and track such an individual and determine that they have committed a crime within the cyberspace, I don't think any reasonable person would oppose punishing, such an individual for engaging in such an act. The other thing we are also dealing with in the cyberspace, now, is not even these issues of hacking, but it has become, a tool we deploy in our politics, and sometimes, unfortunately, we deploy it in very perverse ways. I mean, if you look, especially in the lead up to the 2024 election, and this was something I wrote about it for an organization in Canada, where you're looking at the way technology is being deployed, the kinds of assertions, things that were being said about candidates, that you can literally look up the candidates' own words and the positions they've taken on some of these positions. But again, you run into that challenge of, yes, does the state have a genuine interest in protecting the cyberspace and ensuring that citizens themselves are protected against malice, hacking, and all of those things, but also not including the kinds of things that can get the state to venture into uncharted waters, where it also becomes a tool for dealing with things that you may not like, or political opponents that you may not like. And I'm hoping that through further engagement and consultation, that the amendments to this bill would get us to a place where the state can do what it wants to do without causing unnecessary injury to citizens. And I think that, for me, is my biggest take on this, especially on the issue of discretion, right? In our circumstances, I've realized that when the discretion is vague and the discretion is wide, it tends to be abused than when the discretion is narrow and very specific. So those will be some of the things that I would point out as important in further consultations and engagements to make sure the state can do what it wants to do without unnecessarily injuring.
The portions where they criminalize false statements. Look, I defend journalists, I train journalists, but I've often asked myself the question, what's our problem? Are we saying people should be making false statements and get away with them? So the portion where they want to criminalize false statements, what's wrong with it? But my question to that again is, don't we already have laws that take care of that, which we are already battling with? The famous Section 208 of the Criminal and Other Offences Act, part of the repressive laws that we have been championing, should be repealed, and then the custodial sentencing in them be removed, or the criminal punishments be removed. It says a person who publishes or reproduces a statement, rumor, or report which is likely to cause fear or alarm to the public or to disturb the public peace, knowing or having reason to believe that the statement, rumor, or report is false, commits a misdemeanor, meaning you can go to jail up to 3 years. This is 1960. And then in 2008, in the Electronic Communications Act, we provided in Section 76 a similar provision saying that if you are using electronic communication to do any of those acts which will imperil, safety, you could go to jail for up to 5 years. What do you say?
I mean, if there are laws already on the books that can deal with some of these issues, then I am one to say that you don't need to reinvent the wheel. Perhaps what is missing is not so much new rules and laws, but rather greater enforcement of what already exists in the books. I know it is sometimes some of the things that you read on, in cyberspace, especially on social media, some of the things that people have said, some of the things that people say, you look at it and they say it with so much certainty that you would think they were there when it happened. But sometimes some of these things are untrue, and when you have private conversations with individuals about the path that this can potentially lead us on. You usually to hear things like, well, people can choose to decide what is true or not. And the person who feels injured can always seek, for example, a civil remedy against such untruths. So again, if there are laws on the books, enforce them, but there's always that tension, between what is truly the state's interest and how do you also make sure that innocent citizens don't get caught up in this web of misinformation and disinformation that we are all struggling with, and how do you appropriately deal with it?
Okay, thank you very much. And so, Sule, in the end, your proposal, just in some 30 seconds, we need to go for a break and come to the special prosecutor and interrogate if what he's doing is doing it rightly. The UNESCO and various other, world bodies have said we should not criminalize speech or speech conduct. So even these repressive laws, you have been on the campaign at Media Foundation with the GJA insisting that they should be completely removed. Some of us have said, yes, we need to check because otherwise there's too much of false things people are doing and they're happy about it. We shouldn't allow it. So punish it, but don't punish it as a crime in a civil manner. What should they do to this? What would be your recommendation where they are seeking to punish false, statements using all forms of digital means?
Well, I think that any introduction of criminal sanctions against statements that are made offline or online basically amounts to the reintroduction of criminal libel, which we repealed, we've been happy about, we take it as a mark of progress in our democracy and all of that. As I did indicate, I think that we're at a point where as a nation, we really have to take a serious and critical look at our cybersecurity space or our cyberspace, digital space, and how we sanitize it in a way that will promote our development rather than cause a lot of troubles for us. But that does not mean, in a rush to do that, we criminalize everything. In fact, if we say people who make false statements must go to jail, I think a lot of those, the people who go to jail will be a lot of the politicians. If you look at our fact-checking reports, and look at how many statements have been marked as false and so on and so forth, it will be a lot of these same politicians, both opposition and government, who would be at fault. And so I think that we need to, I don't think that we have to rush with this. I think earlier they even gave a very shorter notice. And then after some comments, then they said, okay, we give you up to 14 days or so.
You think 14 is enough?
No, it is not. Absolutely, no, absolutely not.
About how long?
I don't see the rush. It's not as if Ghana is in a state of emergency over a particular issue. This is a very, very critical matter that affects almost every aspect of our development. Let us take our time, discuss it, debate it, so that at the end of the day, and countries have done it.
Right.
Other countries have done it.
So, Prof, you support that the time should be extended, not
why not?
The 14th?
I mean, in the interest of the state. But then again, I'm not privy to any, possibly there's a national security interest that I don't know of. But if there's no agency...
this one, you can't make a blanket support.
Charlie, it's not a support. I'm just saying, I'm making... when...
You don't have to qualify it.
No, I need to qualify it from where I sit. Sometimes there are probably some briefings that I'm not aware of as far as the national security element is concerned.
Should there be more than time?
But there's enough, if there's enough
from
time,
what you say, do you sincerely think that Akufo-Addo did not regret that he led the repeal of the...
Maybe we should, because if that was on the books, they wouldn't need to do this. They brought it and they are, bringing a new version that's almost on steroids. The Section 208 that you referred, it is more punitive even in the misinformation, disinformation, the scope, the requirement, all right? That whether you know the thing or you don't know. Whereas before, you must know that the thing is false in order to be liable. But here they say that even if you don't know...
I was asking about the time.
Yeah, I agree. But quite simply, if you say something and I just share with the notion that, something is well researched and so therefore it's okay, I am liable just because of that. It's terrible. So my thing is that time is not even the matter here. Let's take a clean sheet of paper. Let's start this process all over again.
Prof, in some couple of seconds, should the time be extended beyond 14th November?
yes, if that is what would get us to comprehensively gather all the necessary
What's
feedback
the if you bring in there? Do you want more time?
Selfish.
Yes,
Okay.
let's extend the
Okay.
time. Let's make sure that, things that must be done well must be done really well.
Okay.
And so you don't want, time to be a constraint where
Thank
you're
you.
trying to rush.
Thank you so very much. And we'll be right back to go to the Office of the Special Prosecutor, taking by bashing, just like the Attorney General also took for the oral pronouncements, which were deemed prejudicial to the court processes. We'll be right back.